Hello, everyone, and welcome to today's webinar. This is going to be a really interesting session with Streamsowers Köhn, which will cover the potential for Nigeria's oil and gas industry under the proposed new Petroleum Industry Bill. My name is Joanna Lane, and I am the editor of Chambers Canada, Africa, the Middle East, Caribbean, and Offshore. I'm delighted to be joined by Streamsowers Köhn partner Chiogotsi Hilary Nwakonko, Dr. Timothy Effiong Okon, Managing Partner of Tino Energy Resources, Curtis Mallet Provost Colton Mosul Partner Mark Hammerson, and Senior Associate at Streamsowers Köhn, Gloria BM, who will be moderating today's session. The session will last approximately 45 minutes. If you'd like to join the conversation, we're able to accept questions via the text box on your screen or by emailing events@chambers.com. You can access key resources belonging to today's discussion using the Event Resources box on your screen. And if you should have any technical issues, please click the question mark button at the bottom of your screen where you'll find some helpful tips. So without further ado, let's begin. Over to you, Chiogotsi.
Right. Thank you, Joanna, for that introduction. Looking at the expertise and the diverse experience of our panelists, this promises to be a very enlightening discussion. So to start off, we'll take a quick look at the history of the PIB and where we are today. As we all know, globally, the oil and gas industry is a heavily regulated industry, and governments are generally very interested not only in regulating, but also in actively participating in the sector. And Nigeria is not any different. The Nigerian government is very interested in this sector and over time has regulated it through the Office of the Minister of Petroleum Resources. The revenue from the oil and gas industry forms a significant part of government revenue. And so government is also interested in influencing all aspects of the value chain. However, unlike other jurisdictions or other countries that have updated their laws over time to cater to changes in technological and even commercial advances, Nigeria has not changed its laws very much in the past 60-odd years. In fact, you dare say there has been no change to the primary legislation. The PIB proposes an overhaul of this legal framework and the introduction of a fiscal and regulatory to tackle the issues that have been identified by players and observers alike. As we all know, again, the PIB there have been many iterations of the PIB. It's been going around for 15-odd years, and none of those bills has passed. We hope this time is different and that the PIB passes. Some iterations of the PIB bundled the issues into one. Other iterations sought to deal with the issues piecemeal. The PIB 2020, it's one bill that seeks to deal with all the issues. It provides a regulatory framework, a new fiscal regime. Provisions have been made for midstream and downstream activities. Host community issues are also dealt with in the primary legislation, and there are also provisions for administration of leases. We hope this time, the bill goes through as passed, and some of the changes that we hope for come to be. The ultimate question, however, is whether the PIB is fit for purpose. And this question is pertinent given the global shift from fossil fuels to greener and more sustainable fuels. To take us through this discussion today, we start off with two presentations from our panelists. Our first presentation is from Mr. Chiogotsi Hilary Nwakonko, and I'll just pass on to him to take us through that.
Thank you very much, Gloria. Thank you, everyone. Happy Easter in advance. Certainly, with regard to I hope you can all hear me, with regard to the PIB, change has been a long time in coming. And finally, it looks like it's actually here. Why do we feel so confident this time? Because finally, it looks like, the stars are well aligned. The executive and the legislature are aligned, and they look like they actually mean to do this. And one has to say that this particular iteration of the PIB has moved a lot quicker than past ones. Okay, so fingers crossed, it will pass this time. So that's why we're having a deep dive, or perhaps an overview of it that gives you enough to understand what's coming down the pike. Okay, so what we're going to talk about today, essentially, we'll look at the overarching themes, then we'll look at the four main aspects of the current PIB. That's governance, administration of industry segments, host communities development, and then the fiscal regime. I'll just whiz through fairly quickly. I don't have a lot of time to do the presentation, so we'll get to the questions and the discussions. Okay, so the overarching themes for the governance part, basically, all this is in line with what you would call modern day reform petroleum industry legislation. And that's to create efficient and effective governing institutions with clear and separate rules. It's important to bear that in mind. The other thing is to shine a light of transparency and accountability in the administration of Nigeria's petroleum resources. The oil and gas industry has been infamously opaque, not just in Nigeria, but globally. Many other countries have made the move quicker to try and open things up. Again, there's a framework created legislatively this time for development of the host communities by the operators in the actual communities, other than what's been done in the past, which has been a little bit somewhat removed, and the interactions with the communities had been contractual. And then, of course, finally, with the fiscal regime, encouraging investment and trying to balance rewards and risks. That's what the PIB promises to do. So quickly, governance, this separation of rules, the minister is supposed to focus on policy. If you have a look at the amount of space given in the bill to what the minister is supposed to do in policy, and you compare that to what the regulator is supposed to be doing, you would think that policy is just a very minimal rule. But frankly, policy is the foundation for regulation and commercial activity. So don't go thinking that the minister isn't going to be important in this regime. He's still going to be supervising the affairs and operations of the petroleum industry. What that actually means is something that will be elucidated probably in due course by litigation, unfortunately. And this is what happens to all laws. Bear in mind, the minister will be able to give general policy directives which have to be complied by the Commission and the authority, which are the new regulatory institutions. These directives are going to be published in the Gazette. So it's not going to be a letter going from the minister to the regulators, which is top secret, and then you just see the outworkings of it all. Okay? So that's the minister's role. The minister's role is still very important, but it's going to be limited to policy. Now, some of the issues that would come up would be, like I said earlier, elucidating what this separation of roles actually mean. Okay? If you see the framework of the Act, the minister is separate from the president, from the regulators. But in reality, what we found in Nigeria is that sometimes the minister and the president are one and the same. So in that sense, when you have that occurring, you could say that some of the safeguards that have been put for the separation of roles are eroded. The other thing, though, is if you look at the Act, there isn't enough put in there to suggest that the minister will actually be able to have a policy think tank or something that will enable him to, the office of the minister to have an institutional memory about policy and what goes on. But this is certainly clearing things up in a way that we didn't have before. So let's look at the regulatory institution. You have two: the Commission and the authority. The Commission for the upstream and the authority for the midstream and the downstream. What essentially are the key things for you to note here? First of all, the scope of regulatory power has been expanded, whereas the DPR currently, has been trying to assert some sort of commercial regulatory power. It's not clearly stated in Petroleum Act, but in the PIB, it's clearly stated there. So the Commission and the authority will be monitoring financial stability of operators. They will be supervising costs and cost control. Okay, the plans of operators would have to be approved commercially by these agencies. Okay, for the authority, they've been given competition regulation power. you could say that this clashes somewhat with the new competition commission that's been created in Nigeria. But the act says, I mean, this bill says that they're going to manage responsibilities on competition together. There's going to be a transparent register of interest, which is not what we have at the moment. So there again, you see some transparency. So I haven't said much about NNPC because, frankly speaking, there isn't much to say. What you need to know is that there isn't going to be a mandated privatization. NNPC will be incorporated as a CAMA company. There's supposed to be no reliance on government funds. There's a mandate for renewables and gas utilization, which really is going to be Nigeria's future. And there's a provision for conversion of unincorporated joint ventures to incorporated joint ventures. We'll see how that works when we get to the panel discussion. Nigeria is moving into a modern lease administration system, okay, with new licenses, a national grid system. Title to data is more explicit, is explicitly stated to belong to the state. Okay, smaller acreage sizes, drill and drop, competitive bids, essentially with limited exceptions in the case of nation-to-nation deals. You're going to have a minimum work program. You're going to have to back that up with a bank guarantee. There's going to be deemed approval on certain applications if the government doesn't respond on time. These are innovations which are modern and brings Nigeria more in line with what you find elsewhere. Okay? So you have still ministerial consent for assignments, but this time, one of the biggest issues for some of us lawyers and operators here, is resolved legislatively. The change of control provisions, change of control in some regards, is now treated as an assignment. So that puts to rest, most of the controversy. Okay, the grounds of revocation are much more clearly stated. Again, we have provisions on voluntary conversion. You are incentivized essentially to convert from OPLs to PPLs and OMLs to PMLs. We'll see how that works. Okay, there's going to be interest on defaulted payments. And then there's, domestic gas supply obligation is there, like we have already, but there's also the possibility of a crude oil supply obligation that might kick in. Okay? For the downstream and midstream, this is really important, and many times people tend to focus only on what's happening in the upstream. But this bill promises what I would call a revolution, really, or it lays the foundation for a revolution in the midstream and downstream, which in a transition era must be the future for Nigeria, okay, in the petroleum sector. There's a whole raft of licenses and permits that are created. Literally, you won't be able to breathe without getting a license or permit in this area. Assignments are subject to the approval of the authority for everything other than, I think, refinery licenses and assignment or refinery licenses. Tariffs are going to be set. The principles are set out in primary legislation. Open access as well, which is a very good thing to bring us into the modern era. Host communities development. Whereas at the moment, you have the NDDC, which is, I would say, several steps removed, really, from the communities in the sense that NDCC is not an operator in the community, okay? That is still being tried. Some would say that it's failed. At the moment, companies have been dealing with communities through GMOUs, and most of those were not legally binding. And even if they were only binding at the contractual level. Now you have something that's actually been put into the law. As every legislation is compromised, you could argue with it and say that it doesn't really work very well, but it's there, and we're going to see whether it means that communities are going to be able to hold companies responsible. See how this works. Fiscal regime. This is an area which has been updated completely. What you have now is a dual tax system, CIT, with the hydrocarbon tax. royalty, a windfall royalty based on value, royalties based on volume, based on terrain as well. Overall, I would say that it's much more incentivizing for investment. You have your normal capital allowances, you have production allowances, rather than the investment allowances that you have now. But we'll be able to go that into that in more detail. So at the end of the day, the PIB is bringing us into the modern era, and it's a very welcome development. I'm sure, like every other legislation, there'll be, it will be necessary to tease out what it actually means. There's going to be a lot of elucidation by regulation, but overall, I think it promises very good things for Nigeria. Thank you very much.
Thank you, Chair Gozie, for that presentation. We hope to go into these issues in the panel discussion proper. So we move now to Mark Hammerson. If you could just take us through your presentation as well. Thank you.
Thank you, Gloria, and thank you, Chair Gozie. I know people really want to get to the panel discussion and also the Q&A. So I'm going to try and go through my slides relatively quickly. If anything catches your interest, then please just raise that during the Q&A. So these are the topics that I'm going to be talking about today, the international challenges, how the PIB seeks to address those challenges, both in Nigeria and also internationally. The scope of the four institutions, the old institution being the minister, the old institution, NPC, in its new incorporated form, and then the two regulators. And then finally, no energy seminar is complete nowadays without the ubiquitous discussion about energy transition issues. So we'll touch on those as well. So let's first of all just think about the PIB in an international context. Now, I've been asked to just maybe approach this talk from the point of view of an international investor. So on the international oil and gas scene, we got various headwinds. We got price cycles, global pandemics, energy transition issues. We got what I think is a lack of private equity interest, or a waning of that interest. And then we've also got demographic changes with the oil majors pulling out and new entrants coming in. So how does the PIB address this? I think that the longevity of the process has not helped. And I think that is a fairly uncontroversial thing to say. It's taken too long. And maybe if you talk to people about Nigerian oil and gas, the first thing they mentioned for several years was the PIB. So the fact that it's coming to a conclusion has got to be a good thing. So in terms of the positive factors, in terms of certainty, we've now got legislation which, as Chair Gozie mentioned, should be in place, and the stars, as Chair Gozie mentioned, are now aligning. In terms of the fiscal regime, people may agree with the changes or disagree, but I think we do have certainty in terms of the fiscal regime. In terms of regulation, I think that is a more open issue, and I think is a good start. But the regulations need to be implemented, and they need to be implemented in an independent way. The PIB is big on gas, and that's not surprising given the amount of gas which we find in Nigeria. And then finally, in terms of the international scene, Africa, I still think, is an attractive and active part of the world for people to invest in. And then finally, and this is relevant to the PIB, where is the new money going to come from in terms of the oil majors, private equity maybe stepping out? I think the new money is going to come from NOCs. And I think we're probably about to see a renaissance in NOCs in the oil and gas industry who are able to raise money on the public markets. And I think the PIB is a very good vehicle for NNPC to step up to that challenge. So the stated purposes of the PIB, there's some worthy aspirations in here. The two that I want to draw your attention to is the second one down on the left-hand side, to establish a commercial and profit-driven national petroleum company, and that is what we now is going to be called NPC Limited. And then the second one on the right-hand side, to develop third-party access arrangements for infrastructure. And I see that as being really important for the much-needed development of downstream and midstream gas developments in Nigeria. The amazing thing about the PIB is it's got 319 clauses, and of the 319 clauses, only one relates to the Minister of Petroleum. Of the 15 powers given in Section 3, 4 are conditional on a recommendation of one of the regulators, and one is the power to delegate authority to the Commission and the authority. So of the remaining 10, as Chiagozi mentioned, one is to formulate policy, the other one is to deal with the federal government in terms of the international community. But essentially what the PIB represents is a major shift of political power to an independent regulator. And I don't think that point can be underestimated, that it is a wholesale shift of political power to regulators. In terms of international investors, the ones that caught my eye were the anti-assignment power. So this is now within the hands of the Commission, a recommendation of the Commission. And it's deemed to be granted after 60 days. So hopefully that will take away some of the weight that we've faced in the past. And also, as Chiagozi mentioned, we've got change of control, which is now explicitly falls within the anti-assignment provisions. And we now have a reference to it needs to be a change of control over 50%. And that was actually something which was missing previously from the DPR guidelines. So that clarification, I think, will be of comfort to international investors. And then finally, the Commission determines the M&A fees payable on any license transfer. And I've seen international investors worry about the uncertainty of potential fees payable. So I think that provides well-needed transparency. But generally, I think what this points towards is an increase in the speed and transparency of doing deals in Nigeria. And international investors do those deals with an exit in mind, and to be able to provide them with more certainty as to what that exit will be, I think will be of comfort to them. So the Commission essentially takes over the power of the Minister. It effectively takes on the powers of the DPR. It regulates the upstream industry. The authority regulates the midstream industry. As Chiagozi mentioned, there's now going to be a public register of OMLs. I think that will undoubtedly be beneficial to due diligence processes and essentially take out some of the lack of transparency in ownership of OPLs and OMLs. So I think that's quite a big task, and the Act talks about both the legal and beneficial ownership. And I think knowing that will be of great assistance to investors. The Commission will issue guidelines, and guidelines, I think, are a very flexible way in order for people to be able to regulate the oil and gas industry without all the political difficulties which we've seen with the PIB and the length of time that it takes to get it over the line. And then finally, the Commission is going to be funded by the industry, and I think that self-funding is going to be important for the Commission to actually assert its independence. Many of the comments I made about the Commission are equally applicable for the authority, which is the midstream and downstream regulator. And in the interest of time, I won't go over these again. Others to note that there's third-party access provisions. And I think in terms of trying to develop a midstream and downstream market in Nigeria, I think the ability for people to access other parties' infrastructure is enormously helpful. An NPC becomes an NPC Limited. And I think the point I would make here is NOCs are not homogenous. So many NOCs over the course of their life have been commercialized. You think of Saudi Aramco recently, Equinor, Petrobras, etc. So the journey for NNPC is a very natural one, and it is one not to be feared. It's interesting to note that there's a prohibition on government funding for the new NNPC Limited. And that's designed in order that it attract investment with a mandatory edict that it needs to also develop renewables. My final slide is on energy transition. And I would just sum up, there's been some criticism that the PIB doesn't address energy transition. I think that's mistaken for this reason. Oil and gas laws have a hierarchy. You have the Constitution, you have the petroleum law, you have regulations, you have guidelines. There is a very limited amount you can achieve just by legislation itself. Legislation is quite a blunt instrument. But what I think the PIB does is set out the parameters in which the industry, particularly now led by independent regulators, can go forward. And one hopes, with some of the sections I've mentioned here, that the regulators will develop the industry, taking up the reins of the PIB in order to develop gas, which many see as a transitional fuel for the future. So with time in mind, I will wrap up there and pass on to the next speaker.
Thank you, Mark. Thank you for that presentation. We will go straight to the panel discussions. I think both speakers have identified the regulatory framework as a major factor in overhauling the industry, and it's a provision that the PIB has made one of its focal points. So I'll just start off right with Mark. Would you say that this regulatory framework is adequate to address the issues that have been identified? We have issues of transparency, inefficiencies, and the inevitable costs that come with all of those. So would you say that the regulatory framework proposed deals with these issues adequately? And specifically, how does this compare with other jurisdictions?
Well, let me take the second question first. So actually the UK about 10 years ago split the regulatory role of the government into a separate, it's called the ODA, the Oil and Gas Authority. So this has happened in the UK, and I've actually seen countries in the Middle East and Africa who have actually started their oil and gas journey by splitting the regulator from the government. So, certainly it's been done. It's, as Chigozie said, the more modern way of organizing an industry. To your first question, does the PIB do it? I think it is a work in progress. So I think the PIB lays the groundwork. Independent authority. But the regulators need to assert that independence. And I see this very much like central banks around the world. Central banks gain their powers by vigorously asserting their independence. And it is now for the regulators, when they are set up, to ensure that there is no interference from government, and that they do establish the reputation for transparency and independence. So to your first question, I think it remains a work in progress, but the PIB lays down very good groundwork for it.
I think that there would have to be inevitably a transitional process, a transition, and the industry and observers alike would have to adjust to the new regulators, and the new regulators asserting their authority, just as you've mentioned. To bring this home, Dr. Köhn, what do you expect to see from these regulators? And looking at the letter of the law today, do you feel confident that the regulators can take on the challenges in the industry?
Okay, thank you very much. I think there's a context to this, and this is the context I would like to give. Yes, the work of those drafters of the PIB was essentially to lay the groundwork, and I think I echo what Mark has said. The key challenge would be what would be the lines that the new regulators will draw in the sand and establish precedents as you go along. There is a context to this. There will be 24 months of intensive regulation writing. Those regulations will now be consistent with what is prescribed in the law. So I can indicate to you that each of any reference to regulation in the bill, it has a register in which that regulation needs to be drafted. So there is that 24 months to get all this accomplished, whether it is with respect to the national oil company or the regulatory institution. The second part of it is the human capacity development. The midstream and downstream has historically been not an area in which there's not been experience with regulatory practice, and therefore there is a lot of catching up to do with respect to that. So yes, there'll be initial challenges because once the team is appointed, you are now going to develop certain precedents, and they would have to work towards doing that. And so the work in progress comment is quite apt. Finally, I also do think that the reasons why certain elements are included in law, including things like voluntary conversion to IJV and certain options that are created within this PIB, is exactly recognizing the energy transition. We don't exactly know going forward how this would be framed and shaped. For example, these are going to be things that the regulatory environment would have to adopt. While oil and gas will still remain of some significance in Nigeria and many parts of Africa, but how each nation will cope with that challenge remains to be seen. I will just add another comment with respect to the role of NOCs. And within the 24 months period of transition, as it's embedded in the law now, the national oil company would have to do many things, one of which is to have reorganized itself. The assets will be assigned to it, and its pathway to the future, including its ability to raise capital. The constraint of not being funded by the state is a deliberate one. So I will just leave it at that. But this foundation, the basic framework has been set, and I think precedents over time will see how well those institutions would perform.
Okay, thank you, Mr. Köhn. I think there will definitely be some teething issues when the regulators, begin to work, and the test really may be the willingness and the determination of the regulators to actually enforce the law and bring about the change that industry is looking to. I already anticipate that, there'll be some kickbacks from industry. It's a change and people don't really want to change. But I think if we see clearly that this has been done for the good of, industry and the state, then you would have the cooperation of everyone. But just to bring this home, particularly with respect to the role of the minister, I'll ask Chair Jose real quickly, what do you see to be the role of the minister in terms of his influence? I know the PIB has sought to curb his influence significantly. Do you think that this has been successfully done, or do we foresee that the minister would still be able to influence the regulators?
Well, Thank you, Gloria. Like I suggested earlier in my presentation, I think that the fact that the ministers, the provisions on the minister's role and that many in the PIB doesn't mean that he doesn't have an important role. Like I said, policy making is a very, very important role. And depending on, I would say, the character of the minister or the character of the government, you might find that, that policy whip, if I may call it that, enables a minister to keep everyone in line. And that might be a good or a bad thing. And as we've found in Nigeria, in Nigerian practice, where the president is also the minister, if the president is someone who is actively interested in what's going on, well, he's got everyone on a short leash. Okay, so I think that there's enough there to allow an assertive minister to maybe in some cases interfere, frankly. I mean, if we'll be plain spoken. But the thing is, the idea of the law is to keep these roles separate and, to keep the minister to the policy role. My anxiety actually is far more as to whether the minister is going to be well resourced to play the policy role. Because what we find in recent times is that if he's not well resourced, he will now be reliant on the commercial entity, the NPC, or the regulators to help formulate policy. Because, that separation isn't just one way. It's supposed to be both ways, frankly. Even though you noted that in the law, the regulators are supposed to advise the minister on policy as well. So I don't know if that sort of gives you enough of an answer of what I think the situation is.
I think that answers the question. There are issues to look out for, and again, the test will be in implementation of the bill, of the act, the bill when it's passed into law. But moving on quickly to the fiscals, and the fiscal provisions will be of interest to anyone looking to invest, and even to be of interest to existing players. And I'll direct our first question to Dr. Köhn. Sir, could you comment on the fiscal regime that has been proposed? From where we sit, we know that there's a dual tax regime that has been proposed and a reduction in some of the rates of taxes and government take. So if you would comment on that quickly, please.
Okay, I think, yes, what the fiscal regime or what the fiscals seek to do broadly about 8 different policy elements that are being implemented in what has been done. One is that all companies in Nigeria should pay corporate income tax. And then we have the resource tax, which is what we talk about the dual tax system. Then, of course, you have the royalty scheme, and the royalty burden has generally been reduced, but there is a royalty by price. So it doesn't apply to gas. This is part of the incentive for gas. The royalty by price with respect to oil the trigger being $50 will go to the sovereign investment authority. In other words, that Nigeria will build some kind of sustainable revenues when oil prices go up. This will now be a matter that we prescribed in law. The fiscal regime is designed for an oil price of around $50. So that's then there is a reliance on royalty. So tax rates have generally come down, whether they're the resource tax or the corporate income tax rate has remained the same. There's a move away from, of course, investment allowances because those are cost-based incentives to production-based incentives. In addition, what you now have is an election to either the current fiscal regime or you convert. And those conversion terms have incentives associated with it, lower tax rates, et cetera, et cetera. And when you do convert, of course, you have to forego all the arbitration awards against the state, et cetera, if you want to do that. and new acreage. So that leads me to a third category of fiscals, and these would be related to acreage that has been released. Part of the reason for creating this new basis is that for long, because of the NNPC Act, certain acreage, most of the acreage in Nigeria, you could not relinquish because NNPC was in which case the requirements of the Petroleum Act, the 1968 law, a certain section there was disabled by the NNPC Act, which is a 1977 law. So this now enables a pathway towards releasing new acreage for new activity. And in exchange for that, you have even more generous terms, what we would call the post-COVID terms in the PIB. So that is the basis for the fiscal reliance on royalty so much, because that's right now it's the only secure take that the government actually receives. It's easy to calculate and so on. Taxes are a bit more complicated because that comes after cost. Another feature of the fiscal regime is the cost-price ratio, which tries to manage Nigeria's costs across the board and limit certain cost recovery schemes. This is really a more effective way of managing costs by setting a fiscal rule of general application rather than setting up organizations to manage costs and just basically trying to remove that bureaucracy. I guess this just gives you a panoramic view of what fiscal.
Yes, it does. It does. I was just going to throw my next question to Chair Gozie. I know I've heard Mr. Köhn speak, and I hear him say that these taxes have been lowered. But I also know that there are different under other statutes, and even under the PIB, there are certain contributions that players in the sector are required to make to different funds. Considering all of these contributions and the lower rates that the PIB proposes, would it still be accurate to say that the PIB has, lowered the cost of entry and playing in the sector?
Well, what I'd say is that the costs of operation have been lowered, the royalties and the taxes, but before you enter, you've got to pay some what I may call taxes, which in the recent times, arguably have been increased. So, for example, depending on the kind of oil and gas interest you're acquiring, you're going to be paying things like an application fee to the minister. You're going to be paying a premium based on your transaction purse. You're going to be paying. In some cases, you may be paying value-added tax, okay? And you'll be paying stamp duties. So all these things add up. I mean, I think the government also needs to look at some of those costs, partly because, frankly, we are in a transition era. We don't know how long and how many of the reserves that we have are actually going to end up being produced. So we need to get competitive, even in the small things. So yes, with regard to the PIB, operationally, costs are being reduced. But, the costs of entry also have to be looked at. That's basically what I'd say.
Right. I think that, anyone coming into the industry or even existing players would need to look at these provisions carefully to see how to best take advantage of, the propositions made by the PIB, especially with respect to converting or maintaining the current regime going forward. But when Mr. Köhn was speaking, I picked up on the point he made with respect to the conversion contracts. Now, there are benefits if you choose to convert, but just to, keeping with you, Chair Gozie, would you say that for a licensee, an existing licensee who chooses not to convert, at the point of renewal of your lease, do you automatically, lose your right to, your ongoing litigation, to stabilization clauses and all of those? Or are you able to, would you say, based on the wording of the PIB, that you're able to carry those on?
Well, you don't want me to open up my bag of tricks, do you? At this stage.
I don't know whether you want me to address it or Chair goes in.
Okay, very well. Let me. My answer to that is that I think it's the intention of the bill that that's what happens. But I would say, speaking as a lawyer, it's not really clear cut from the language, frankly. And so maybe to remove that sort of controversy from the table, perhaps that's one area that ought to be looked at, so that it's clear to everyone what actually happens in that sort of instance.
I think there is if I just add, I think there's some clear language actually, and those are being honed. With respect to those who elect to remain and have signed the heads of agreement, etc., those would end up in a schedule, one of the schedules, the PIB. So I think that's I can say clearly that if you choose to remain, you would remain under that regime. Of course, there is not likely to be a guarantee that the OMLs or leases that you have will be automatically renewed on the same basis as before, because even now we have regulations to the effect that anything that is called the back-in rights regulation is that such a renewal cannot be less favorable to the state. Okay, so I think that the options have been created. What we want to be clear about is that these options that are created, you don't benefit from both sides. You don't benefit from current existing, then you move into the conversion state, and then you benefit as well. That'll be double dipping. And I don't think it would serve the best interest of the state. So if you choose to remain, then you remain under that setup. If you convert, then you benefit from the new terms. You cannot carry stabilization into a different sort of with. In other words, you can't cherry pick all the incentives. You go under. It's like under CETA. You are a manufacturer. You receive this. You are a processor. The FIRS does not, tax administrators don't like such things. So even if anyone intended to do that, you have to cross a hurdle, and tax administrators like to see a fiscal system that is implemented favoring none, but applied to everyone on an equal basis. Yeah.
Okay, I think I'll pick up on this conversation with you afterwards, Mr. Köhn, because you make some very valid points that I would like to follow up on. I am conscious that we are almost out of time, so I'll just go really quickly into the midstream and downstream opportunities that have been created. Under the Petroleum Act as it is today, not very much was done for the midstream and downstream, and the PIB has made copious provisions, licensing provisions, and I dare say, perhaps there's more opportunities in this sector for people who are looking to come in. Mark, in your experience, would you say that these provisions are attractive? Do you see more work coming in? Do you see more expressions of interest, or do you think that some bit more needs to be done?
Well, let me say this, and I'll try and be short because I know time is limited. So do I see interest? Absolutely. I think you can't have a day go by at the moment without reading about some new midstream or downstream Nigerian gas opportunity. Will there be interest from the international community? For sure. But to develop gas is an ecosystem. And in order to develop that ecosystem, one person needs to rely on another person who needs to rely on another person. So it's a very hard thing to develop. But the certainty of the PIB and any regulations which are developed by the authority as the midstream and downstream regulator has to be an attractive proposition for both domestic and international investors. So yes, I think the PIB provides a good foundation on which the Nigerian gas industry can flourish and develop.
Thank you, Mark. I think, looking at our electricity sector and other strategic industries, that would be very welcome. We hope that the PIB passes quickly and is able to incentivize investment and even development in these sectors, especially for gas. Again, conscious of the time we have very little time, unfortunately. I'll just move quickly to another very thorny issue, the host communities issue. Now, with every iteration of the PIB, there representations are made from host communities on, sort of provisions that they would like to see in the bill and how they think these issues can be best dealt with. The PIB proposes a trust structure to deal with these issues. And I'll pass my next question to Mr. Chiagozie. How would you say that this would be implemented practically? And what's the impact or what's the implication you see for settlers?
Well, to answer very quickly as well, I would say that the PIB tries to do a number of things, to legislatively regulate the relationship between the operators and their host communities, okay? It hadn't really done that before, especially with regard to host communities development. Now, I think with the trust structure, a lot of it will have to be fleshed out by regulation. Okay, there are a number of questions that still need to be answered. For example, are you going to have trust for each host community, or can you have maybe a lease-wide trust, for all the host communities within the lease, okay? And then, to me, it's not very clear. I mean, I'm not an accountant. 2.5% of actual operating expenditure. I don't know what that means. Does that include capex? So these are some, as much as possible. This area is very important. And it's also an area that, can lead to a lot of controversy. I'm sure a lot of people saw the videos going viral where, people from the host communities at the hearing, so some people came to fisticuffs just because someone didn't like what someone else was proposing. Okay, so this is an area that needs a lot of clarity. And I think that, a bit more work can be done in the bill to work this out. But bear in mind that if you use a trust structure, you have to be clear who the beneficiaries are. What legal rights do beneficiaries have against their trustees or the settlers? It's not very clearly stated in the bill, okay? Or would the normal provisions of the law apply in this instance? So I think there's still a bit of thought that needs to go into making sure and outworking that is to make sure that this works as seamlessly as possible. But it's an advance. It's better than the NDDC, which was, far away, and people were spending money they didn't have, and today it's not functional and it's mired in controversy. So I think this is an advance, and a welcome advance, nonetheless, in spite of the issues that it might have.
Okay, thank you for that. I think we move now to the final part of our panel discussion, and that would be opportunities for business and each panelist's view on the PIB. Now, my first question is this. We are in a transition. Globally, there's a move from fossil fuels, and as Mark identified in his presentation, there would also be a sort of change in the financing for oil and gas activities. we are passing the PIB in that mix. And the Nigerian government has also declared a decade of gas, right? My question then is, what sort of opportunities do we see coming up? And do we think that the PIB is positioned to take advantage of this transition? So I'll start off with Dr. Köhn.
Okay. My answer is an emphatic yes. I think I'll refer to the comment I made about the role of the national oil company. There's 24 months to capitalize, to acquire assets, and all of that process. So within the context of that decade of gas, you're beginning to see moves. One, it's the investment in the methanol plant with NCDMBs, an indication of what can happen in the midstream. And it is the national oil company and various and some of the funds that the midstream fund, etc., which actually is not a burden on the upstream, is actually a 1% burden placed on products that are sold in the Nigerian market. So it has nothing to do with the upstream. So it's not an additional cost to the upstream, which is really a misunderstanding of what the law provides for. But those funds will be used in many areas of incentivizing midstream opportunities. And so the PIB is singularly focused on that, where the mindset has moved out of increasing the taxes for the upstream to making sure that Nigeria going forward actually has a healthy manufacturing sector out of its oil and gas businesses. So you're seeing the methanol plants, the fertilizer plants, all of those things are going to prominently begin to play a big role.
Thank you,
and the national oil company.
Right, sorry, I just have to interrupt you real quickly because we are just about out of time. And I need, I'll pass on to Chair Gozie, please, if you could just give us your thoughts, your final thoughts on this issue. Hello?
I'm sorry, I was muted. I second what Dr. is saying. Basically, I think the PIB is a welcome legislation at this time. I think I'll just leave it at that so that Mark can also make his contribution and we can move to the Q&A. Yeah?
Right. Mark, please.
So just concluding thoughts for me, I'm going to take on the theme that people are talking about, which is gas. So Nigeria, as everyone knows, has got abundant gas resources. There is enough gas there both to develop the downstream infrastructure which Nigeria needs, but there's also enough gas there to export. So I think when we've talked about gas a lot as a domestic product, but let's not forget about the benefits to Nigeria of having gas also as an export commodity.
Thank you for that, Mark. My final question for the panelists was, if you thought that the PIB was coming just a little bit too late, but based on the responses I've just gotten, I think that there's still use for the PIB and there's still, we still have a lot to get out of it. So with that, I will bring our panel discussions to a close and then move on to the Q&As. We've received quite a number of questions. I'll run through real quickly and see which ones we can pick up. I have a question here, and so this participant says, my question is with regards regulation of operators caused by the authority. Do you not think that this attempt to regulate private contracts is overreaching on the part of government? And how does this tie in with new cost optimization program by the upstream sector? So I will throw this to Dr. Köhn, please.
Okay, I think The answer is simply no. When costs are lower, the operator, the investor also benefits. So if you just look at what I call the economic rent equation, so your revenue minus cost is equal to your margin or your profit plus government takes. So there's so if your cost is lower, what is shared between the parties also go up. So there is an interest by all the parties to make sure that cost is well. So if an operator, an investor is insisting on a higher cost, it may be that then cost has become a profit center, which they pile on costs, and you keep hearing of things like a profit premium, a cost premium on Nigeria, and so on and so forth. And remember, most of these now have moved to the deep offshore. So you can't be talking about pipeline vandals and so on and so onshore. So that's the challenge. I think that that isn't overreaching, because it is the benefit of both the investor and the government that costs are properly managed.
The lawyer in me seeks to say, my gut reaction is, hold on, you can't intrude on my contract. But I understand what you're saying, Doctor. We also have a question here, and it says, are existing licensees assured of being granted new licenses under the new legislation? And will their existing license rights be exactly replicated, or would it be on different terms? So I'll throw this question to Chair Gozie, please.
Okay, like Doctor explained, you have the option of continuing under the license regime that you have presently. My reading of the bill is that under the Petroleum Act, or even under the PIB, you would be entitled to get a renewal if you satisfy the conditions in the Act. Okay, so the question we were addressing earlier was, whether, at the end of, suppose you are under an OML regime now, the existing regime, and it comes to an end, would you be mandated to convert? And if you converted, what would that mean, for example, to existing cases you have, to assert your rights and all that? Doc says that, the language is pretty clear about that. Well, I'm a lawyer, and it's my job to perhaps, find ambiguities. I think it's not quite as clear. But to answer your specific question, Martin, I think this is Martin's question, I can see from that. So yes, you're not going to be, if you opt to remain under the current regime, you won't be dispossessed. But if you decide to convert, then you can run along.
But you won't get the benefits of conversion. That's just all. You wouldn't get.
Yes, of course. Of course. If you don't convert, you won't get the benefits of conversion. You just remain under the current fiscal regime as well.
Okay, so we have room for one more question. And this is a question, I think it's about the funding of the regulator. So it says, given the constitutional definition of revenue, will there be challenges concerning the proposed financial autonomy for the regulators? The worry is that certain litigants may challenge such provisions on the basis that such funds ought to be paid to the Federation account. And are there practical options to assuage these fears? So I will go back to Mr. Köhn real quickly and then check, see if Mark has anything to add. So Dr. Köhn, please.
Well, that is for the Commission and the authority. All funds that are due to them are appropriated. Okay, so that's royalty will still be paid to the Federation account and etc. So paid and what is not paid. And I think there is quite established law now. I think BPE versus I think Ogun State and others, which the Supreme Court ruled that net proceeds go into the federation. So there's pretty much clear practice here, legal practice with regards to, and all funds that are expended by the regulator, those two regulators who did by the National Assembly, the same way that that is done now. So there wouldn't be any risk of someone redefining what revenues are or net revenues, as this may be.
Okay, thank you. So finally, I'll just ask Chair Gozie if you have any comments on this regulator pay proposal of the bill.
Well, you've asked the non-lawyer the legal question, and I think you gave a pretty good answer. So I think
right. So please chip in the lawyer bit.
A pretty good answer. Yeah. So.
Right. Okay. So thank you all for attending this webinar, and thank you to our panelists for an engaging discussion. I'll just hand over to Joanna now. Thank you.
Thanks, Gloria. So unfortunately, that's all we have time for today. Many, many thanks to Streamsowers Köhn and to all of our speakers for today's insights, and to you, our audience, for logging in today. We had a lot of questions that we haven't managed to get to. Should you have any follow-up questions that you didn't get to ask or that weren't answered, please do get in touch with the firm directly using the contact box on your screen. So I wish you a great rest of your day, and I hope to speak with all of you again soon. Goodbye, and thank you again.